Good afternoon, ladies and gentlemen. We are students from the University of Zimbabwe, Faculty of Law, Department of Undergraduate Studies doing Commercial Law, which is being taught by Mr. Eni Maposa and Ms. C. Chigogo. We are Group 22 and we are presenting on construction contract. My name is Pixel Mgoa and the other group members include Michelle, Brittany, Bianca, Locadia, Cleopatra, Desire, Munashe, Tamara, Mukono, and Shamiso. So we'll start with the introduction. This is going to be given by Michelle.
A construction contract is a mutual or legally binding agreement between two parties based on policies and conditions. The two parties involved are one or more property owners and one or more contractors. It can also be simply defined as an agreement between an employer and the contractor to construct, repair, modify, renovate, or even demolish something in an agreed time frame for an agreed price in agreed standards. There are different types of construction contracts, namely a lump sum contract, cost plus fee contracts, guaranteed maximum price, time and material, and unit price only. For a construction contract to be valid, there are legal requirements to be met, terms to be agreed on, and in an event of breach, there are remedies to be considered. This is further supported and confirmed by case law and statutes like Contractual Penalties Act, Consumer Protection Act. Generally, the law in Zimbabwe requires every company involved in a construction contract to comply with labor, tax, health, and safety acts. The Construction Industry Federation of Zimbabwe established the National Joint Practice Committee Standards Contracts in 2000. My colleague Brittany is going to elaborate on the types of construction contracts.
So generally there are four main types of construction contracts, as already mentioned earlier. So I'm going to begin with the lump sum contracts. Lump sum contracts are most frequently used contracts, particularly for building construction. The idea is that all aspects of the project are predetermined and laid out in a fixed scope of work. The cost is known and upfront for the owner, and the contractor will be able to manage expectations. The main advantages for this type of contract is that the amount of project is known and upfront before the project begins. However, if any out-of-scope work is needed, a change will be required, which will delay the timeline of the project. And if the project goes out of scope as a result of the contractor's poor time management, rework, or whether the contractor will suffer a loss if a change of order is not used. And the second type of construction contract is the cost fee contract. The cost plus fee contracts, these ones, they do not require a predefined scope of work with a fixed cost. Instead, the contract keeps track of time and the materials spent throughout the project, and the owner is responsible for reimbursements plus a fixed fee for the contractor. In as much as it has a disadvantage of having a significant risk for the owner who is responsible for reimbursing all time and all the materials spent on the project, and a ton of work is involved with these contracts because every receipt and timestamp needs to be accounted for in order to bill the owner properly. Moving on, we also have the guaranteed maximum price contracts. This type of contract combines the first two together, where there is a firm cap over overall contract price, but the owner is only obligated to pay for anything additional needed, similar to a cost plus fee. This option is very popular for those using the design-build project method. So I shall now leave this time to my colleague who is going to tell us about the requirements for a valid construction contract, Bianca.
Under the requirements of a valid construction contract, we have offer and acceptance.
For there to be a valid construction contract, an offer must be made by the offerer and accepted by the offeree. Acceptance is meeting of the minds, where the parties agree to the shared terms of the contract. In a construction offer, one of the parties, which is the contractor, makes a promise to do some specified action in the future, which is construction of the specified building. In acceptance, the offer would have been accepted unambiguously and the terms discussed. The case of Khalil versus Carbonic Smoke Ball Company best explains the requirement of an acceptance. Another requirement of a valid construction contract is animus contrariandi. This is a serious intention to create legally binding obligations. For there to be a valid construction contract, the parties in question should be willing to contract. This is why gentlemen's agreements are not enforceable as contracts, because they lack the intention. A typical case of where animus contrariandi is highlighted as an important requirement for creating a binding contract is Cantor versus Cantor. In this case, a husband called his wife to make an agreement for land, which she failed to honor. It was held that this was not a valid contract because there was no intention to create a legally binding contract. Capacity is another requirement of a valid construction contract. For a construction contract to be valid, the contracting parties should have the contractual capacity. Capacity refers to a person's ability to satisfy the elements required for someone to enter binding contracts. For example, the Engineering Council Act provides that no person who is not ordinarily resident in Zimbabwe nor foreign funds are allowed to carry out any engineering works without being registered with the Council of Engineers. It also means a person has to be competent as defined by the law and are mentally capable of understanding the applicable contract terms. This capacity can be either through artificial or natural persons. If the parties lack the contractual parties, then the contract is voidable. We move on to legality. Legality of the contract between parties is a legal agreement where obligations are mutually agreed upon and that the law can enforce. The general rule is that the courts will not enforce any legal contract. Generally, the law in Zimbabwe requires every company involved in construction contracts to comply with labor, tax, health, and safety acts. Certainty. In construction contracts, parties should always look to ensure that a contract is certain. The terms and regulations being made in a contract should be stated clearly and understood by the parties of the contract to avoid disputes. For example, in the case between Zimunya and another versus Shumba and two others, the issue before the court was whether Zimunya and another had breached the contract or not. The applicant approached the court seeking a remedy after the termination of a contract in a land deal. The court granted the application relief since the issues raised by the respondent were not specifically mentioned in the contract that construction was involved. Lastly, under the requirements of a valid construction contract, we have possibility of performance. The contracting parties in a valid construction contract should be able to perform. If a construction contract has an agreement to do an act impossible, it in itself is void. However, in instances of impossibility of performance, one party can be released from a contract due to unforeseen circumstances that render performance under the contract impossible. Such impossibilities, such as supervenial impossibilities or God's acts, for example, an earthquake. For now, I'll hand over to my colleague Michelle, who's going to elaborate on elements of a valid construction contract.
So I'll proceed to the elements of a construction contract. Firstly, there has to be a full name, address, and signatures of both parties. It is required to make a contract legally binding. Without the proper information or appropriate signatures on all required documents, it will be difficult to get the contract to hold in court. Secondly, we have scope of work. This area should not be overlooked. It should be in great detail, explain the services to be provided, including a description of materials, quality, grade, schedule of work, and other specifications pertinent to the construction of the property. Thirdly, project cost and payment terms. It should be clear and simply stated. There should be no confusion as to cost of services included. The schedule of payments, the amount that is due, and the terms and conditions of the payment should also be clearly outlined in this section of the contract.
I will continue with the elements of a valid construction contract. Schedule of work. There is need to establish a clear notice to proceed date, a construction date, start date, and date of completion. Parties need to be sure to differentiate calendar days and work days. It is also wise to include in the contract who will be responsible for hindrances, for example, delays caused by the property owner in obtaining the required permits, easement and approval, or for delays as a result of bad weather. If there are to be change orders, a party to the contract should be sure to document any additional time they will require. I move on to authority as an element of construction valid contract. With so many moving parts, it can be difficult to establish who has authority to make decisions during a construction project. This is why it is important to make it clear who has the authority to make legally binding decisions before project initiation. This can help save a lot of confusion during the project. Moving on, I will talk about the conditions of construction contracts. There is to be guidelines by which the execution of the contract is to be governed. These set out the responsibilities, rights and liabilities of the two parties. The Factories Act mandates the steps to be taken to prevent danger of fire or explosion through leakage or accumulation of gas, among other safety precautions. They also set out the actions to be taken by the parties if and when certain eventualities should arise. We are moving to the terms of construction contracts, which will be presented by my colleague Lokati.
Okay, so I'm going to talk about the terms of a construction contract. A construction contract, like any commercial contract, records the terms agreed to by the parties, who at liberty agrees on terms and conditions which are not prohibited by law and which do not offend public policy. The rights and obligations of parties to a contract are defined by its terms. There are two types of terms, which are express and implied terms. Express terms are those that have been explicitly agreed by both parties, and they can be in oral or in writing. In drafting of a construction contract, the following express terms are important and beneficial for both the contractor and the landowner. The cost it lists what the completed project will cost and decide whether the homeowner will pay in several installments or. We also have description of work and the completion date. This clause fully describes what is being constructed. It may include specifications, plans, portions of work being hired out to subcontractors, if any, and the exact or estimated date of completion. Inspection and access. This allows the owner to inspect the property during reasonable times to ensure that the work being done aligns with the terms stated in the construction contract and for the contractor to have unlimited access to the property. We also have unforeseen circumstances and acts of God. It provides for what happens if there are unexpected circumstances and acts of God, such as hurricanes or floods. Under express terms also have warranties. It covers whether the general contractor provides for any type of warranty on the work and the period of time in which the work is free from any material defects. Okay, so under express terms also have labor and materials. This term lays out which party is responsible for procuring the materials, as well as any costs associated with labor and materials needed to complete the work. Permits and licensing. It outlines which party is responsible for requesting and obtaining any necessary permits and licensing to complete the scope of work. We also have termination. When either part can legally terminate the contract and any penalties that may apply to the decision to terminate. Moving on, under express terms, we have dispute resolution. The parties must agree on the acceptable methods of resolving any disputes that may arise before, during, or after the construction process, such as arbitration, adjunction, or mediation. Insurance policies. This term allows the contractor and the landowner to agree on which party is responsible for obtaining insurance to protect against any losses and damages, as well as any minimum value requirements for insurance policies. dispose of all materials and condition upon completion. The parties agree on who is going to get rid of excess and hazardous materials and leave the property in broom clean condition. My colleague Cleopatra is going to elaborate more on implied terms of a construction contract.
On the implied terms, there are many terms that are capable of being implied into a construction contract by common law. However, the courts will not only imply terms merely to make the contract reasonable or to iron out the nonsenses and inconsistencies that frequently appear. The express terms do not necessarily constitute all the relevant terms of the agreement. In certain circumstances, the courts are prepared to imply terms into a contract provided such terms are necessary to give business efficacy to the contract. Certain terms are implied into a construction contract by law or policy or practice. For instance, all contracts must comply with applicable laws, and the contractor shall be obliged to follow construction norms, health, safety, and environmental rules, and any other law imposed by the state at all times. Firstly, contractors must carry out all work with all proper skill and care. Materials should be reasonably fit for purpose of satisfactory quality. A duty to cooperate. The employer must do all that is necessary to bring about completion of the contract, but this must be determined by reference to the terms of the contract and not what may appear reasonable. A duty to give possession of the site within a reasonable time. This only applies to certain types of contracts and does not apply to contracts for refurbishment or maintenance. Moving on to breach and remedies. Disputes can be resolved either by approaching a court or through alternative dispute resolution, such as mediation, arbitration, or referral of an expert. If one of the parties breached the contract, the other party may be entitled to damages. The damages may include any costs incurred due to the breach, such as the cost of repairs or additional labor. The non-breaching party may also be entitled to compensation for any losses suffered as a result of the breach. There are different types of breach, namely moral debitories, moral creditories, positive malperformance, repudiation, and prevention of performance. An example of moral debitories is in the case between Midland State University versus Galax Engineering Designs Consultants Private Limited. The issue before the court was whether Galax Engineering had breached a contract or not. The respondent failed to finish the agreed task in time, and the applicant terminated the contract, and the respondent approached the court for remedy. The court awarded the applicant the damages sought. If a breach of contract occurs in a construction contract, the aggrieved party may pursue legal remedies such as damages, specific performance, or rescission of the contract. Under the NJPC, in the event of a concurrent delay, attributable to both parties, the contract damages require monetary compensation for the losses suffered due to the breach. Specific performance is an equitable remedy that requires the breaching part to perform the obligations under the contract as agreed. Rescission is a remedy that allows the non-breaching party to terminate the contract and be relieved for any further obligations under it. In terms of the breach and remedies, the Prescription Act provides for the time limits within which parties may bring claim against each other. As a general rule, in terms of Section 15, the limitation period for the prescription of a claim, usually deaths, for disputes arising from contract is 3 years.
In conclusion, we have noticed that construction contracts are similar to a general contract with respect to the requirements, the terms, and the modes of remedy in case of a breach. However, a construction contract has some special areas to be included, especially in the elements as clearly articulated by my colleague Michelle. We thank you.